the Banacs will come out and start screaming and yelling at my clients.
Stop parking in the driveway. I've asked you 1,000 times.
Here's the harassment crew.
Please, don't park in the driveway.
I
have no right to park here.
Can you leave? Can you move, please?
You're blocking. He's too dumb to know how to get his thing open.
All right. So I know this motion that's in front of us has been going on for quite some time. Are the parties ready to proceed today?
Plaintiffs are, Your Honor.
And to the extent I can be, defendants are ready.
Okay, Ms. Tideman, with that being said, go ahead.
Okay, thank you, Your Honor. We are here on my client's request that the court hold the defendant Banacs in contempt as it relates to the preliminary injunction order that was issued in this case on July 20th, 2023. Procedurally, these are parties who have lived next to each other for a number of years. My clients access their property exclusively through a roadway that runs across the defendant's property. That is the only way into their property. A dispute arose between these two parties, and that led to the request and granting of the preliminary injunction order. And the order specifically states that defendant, I'm going to paraphrase here a little bit, but defendants and all other persons shall be restrained from trespassing on plaintiff's property and restrained from blocking the easement. Defendants are restrained from blocking or interfering with the existing swing gate adjacent to the man gate and access across the entire lane of travel through the width of one gate. So that is sort of the framework of which we are operating under when we request for contempt. And my clients in the declarations provided to the court have provided a number of incidents as well as a pattern of ongoing behavior that is in violation of that order. What I will tell the court is we have tried to be patient in hopes of resolving this. And as my client's declaration provides, I previously sent a letter to Mr. Anagnostou, who was previous counsel, to attempt to get these issues resolved. But we simply have been unable to gain compliance with this order. And it appears that the defendants are confused as to what the obligations of that order would require, or just outright violating it, which from what we are going to present, we believe is in fact the case. There are a number of things that have arisen, and one of the biggest issues that the parties seem to disagree on is ingress and egress to my client's property. So my clients have a gate that they have gated on their property. And actually, would I be able to screen share so I could show some photos to the court while I speak?
Yep, let me get that.
So this is a photo. My client's house is the one straight away. You can see a photo of the gate, and then defendant's house is on the right, and the garage on the right, as well as the vehicle and the trailer on the left is the defendant's. One of the issues, before we get to kind of the more complicated, is that my client's easement rights run 15 feet from, and what had started the case is that defendants on the left side where that trailer was dug into the left side of the bank and attempted to move the easement, and then subsequently started to block the swing gate that you can see by that vehicle that is parked. They had done that with planters and a variety of other things. This photo is taken after the planters and things were moved, but you can see where the driveway is. And the order says that they are restrained from blocking the easement. And then the second sentence of that preliminary injunction, the reason that they talk about the swing gate and the lane of travel as a secondary part of that is because there was a dispute as to the easement. But the easement, by all accounts, runs 15 feet from that left side. And what you can see is that the defendants have continuously parked a trailer directly in that easement. I'm going to try to pull up a different photo. In this photo, the court can see what it looked like immediately after the order was entered. You can see that there is no vehicle parked that is coming out from the garage, and on the side nearest Clammer River Road, which is, as you look at this photo, the right-hand side, there is no trailer parked there. And that is what the clear easement should look like. The easement, when it defined through the swing gate adjacent to the man gate, if the court looks at this photo on the right-hand side is that man gate. And then that first swing gate that you see open, that is the gate that the court contemplated keeping open. With our original materials we submitted, the court can see, and one of the complaints that my clients have is that the defendants have placed rocks, and this trailer continues to be in the easement location. This is nearest the man gate, but that is very clearly in the easement where the court had issued an injunction that defendant should not block. Parking a trailer there certainly blocks that easement. And we have one more photo showing that this is how, if the court recalls, it's a little bit difficult and I can submit them, but from that photo right after the injunction was issued, the rocks that are by that trailer aren't there. We don't have any signs and we don't have a trailer parked there, but now we do, and that has been fairly consistent since the time the injunction was ordered. Defendants appear to believe that that is parking for them and not a portion of the easement. But again, the easement runs 15 feet nearest Clammer River Road, and then that was subsequently not just clarified, but added to that on a preliminary basis because of the dispute as to where the easement started and stopped as far as the gates go, that the whole swing gate would be left open as well as lane of travel. And defendants are very clearly violating the court order in that aspect. The secondary portion that my clients have detailed in their declaration, as well as the declarations of others who have experienced this type of behavior, is my clients put in this gate because they are at the end of this kind of drive. And so they do that because they would have people drive down, turn around in their property, and they are at their property not full time. So they wanted a gate to be able to secure their property in order to prevent that from occurring. They do have to stop and get out to open the gate. Now, the dispute has arisen, and what defendants believe is that somehow getting out and opening the gate is outside of the scope of ingress and egress. And that just simply isn't the case, because what's interesting is when you look at cases that deal with gates and easements, it is almost always the servient estate holder that is placing a gate and the dominant estate holder complaining that that interferes with their ability to access and use the easement. But here what we have is a gate that is squarely on my client's property. My clients use the easement for ingress and egress, but for a minute have to get out of their car, open the gate, and then drive into the property. The standard is that interference with an easement, which is one of the things we're claiming, is that it would be actions that would unreasonably interfere with the use and enjoyment of the easement. And when you look at the cases that talk about gates, they talk very much about how it is reasonable in those cases, even if it's the servient estate, to put a gate that would create a situation where the dominant estate has to stop, get out, use a key, go through the gate, and close it. Ingress and egress does not mean that there is no ability to open a gate and stop. And that is really what is the subject of the problems, or has been one of the problems between these parties. My clients provide pretty clearly in declarations of various dates and when they have accessed the property. And it's almost a consistent problem now where the Banaks will come out and start screaming and yelling at my clients. On March 24th, 2025, my client, Mr. Nanette, details in his declaration that Mr. Banak threatened to kill him. There's quite a bit of angst over this easement that has gotten pretty severe. One of the things we wanted to show today was a video of one of these such encounters as to what my clients are dealing with just to access their property. Can everybody hear this?
Let's fix that.
Hey, April 16th, 2025.
parking in the driveway. I've asked you 1,000 times.
Here's the harassment crew.
Please, don't park in
Here
our
comes
driveway.
the
You have
harassment
no right
crew.
to park here.
Oh.
It's for ingress and egress
Here
only.
we go.
Your solution is to put a lock on your gate and spend more time in my driveway. That's the type of people you are. You're just horrible, horrible people. I'm telling you again and asking you nicely, don't park in our driveway. I don't want you in our driveway. You have no right to park here. You can't park here at all. I know that's hard for you to comprehend because you're really stupid. Oh, yeah. I've asked you, I know you're sitting here for what, 20 minutes now to try to get 10 minutes to try to get your lock done.
Remember the accommodation.
Because you're dumb. So I don't want you parking in the driveway. Use that video, take it to a judge and let him know that you guys are sitting in my driveway, blocking my driveway, sitting here, and you have no right to do that.
Yeah.
These signs tell you clearly that you can't park here, that you cannot park here. So why don't you listen to me? Especially when you're so stupid you can't unlock your gate.
Can't remember the combination.
That's because you're an idiot.
Well,
So you can't park here.
let me help you out a little bit.
You can't park here.
You want a lot of your perceived problems to disappear?
You can't park in my driveway.
Would you like that?
Yeah, why, you selling your place? That'd be the best thing that could happen.
Well, no, we're here for the long haul, but, what I was wondering is, just gotta do a couple of things. And then, a bunch of your perceived problems.
Oh, because what? Because I don't like you building a gate all the ways across my driveway?
Bigger is better.
Oh, yeah. Because I want to fish down there on property that you don't own, that you continue to claim that you own. It's not. I got a letter from the state and a letter from the Cowlitz sheriff. That shows what I'm dealing with you.
Hey,
You're just like impossible.
there anytime.
You are impossible. I got 2 letters that say you don't own that property up here, but you just keep saying you do, but you don't. No, you don't. Sam's saying he owns it.
Can you
Does not
move your
make it
car,
so.
please?
It doesn't make it so,
We
Sam.
want to leave.
It doesn't make it so. And you're blocking my car again.
Can you leave? Can you move, please?
You're blocking. He's too dumb to know how to get his thing open. Why? So you're gonna say that I can't fish down there on
Can you move,
state
please?
DNC land? You're
Can you
gonna
move,
build a
please?
stupid apartment up there that's 3 feet from my wellhead.
Can you move
but
your
you've got
car, please?
Variances that tell you can't build that within 50 feet of wastewater plumbing. You violate that.
Can you move your
Violate
car,
the well
please?
agreement by putting another house on the well.
Remember what I was.
Can you move your car,
You-
please?
Are
Can you move your car, please?
I'm gonna get in my car and I gotta go.
Can you move your car, please? Can you move your car, please?
Just stupid he is.
Can you guys move your car, please? We want to leave. Well, we can't. Yeah, move your car. Don't park here. Don't park
You
here.
can't park in a driveway, Sam.
He's trying to get this on.
Well, this is our driveway and we
driveway.
need to go.
You got a right to go across it.
If there was an emergency, we need you to
But the
Yeah.
easement is to get,
drive
we
through.
own the land. You have property, you have an access to go across
Through.
it.
Not
Not
stop
to
and
park
sit
on
here.
it.
You can't stop and sit here. You can't stop and sit here for an extended.
Yeah, call me an
Oh,
attorney.
the attorney said it was okay.
Yeah,
That-
your
that's-
attorney. The one that you paid $60,000.
Can you move your car, please?
If you were a decent neighbor and you just redesigned that thing,
Can you move your
like
car?
everybody else does, and drive as far away from everybody's house as you should,
Can you move your car, please?
for like $5,000, that whole thing would have been gone.
Can you move your car, please?
$60,000 on.
Can you move your car, please? Hello? I'm asking you, can you move your car?
Park in our driveway.
Move the
Easement.
car.
Why don't you build a barbecue out here, Sam? It's an easement. It's your property. You can do whatever you want on it. It's your easement, man. Build a shed or something.
Can you move your car, please? It's not, you cannot sit here and just park here all day. Huh? Yes, you can.
So I can't get this over.
It's hard to focus while being harassed.
Oh, harassed.
Let me take a deep breath.
Mhm.
No one's harassing you. You're parked.
Mhm.
This is our driveway. You need to move. You need to move. You need to move. Just, you got the keys. Move your car. You can't sit here all day or we'll call the cops. Right. I can call the cops on you if you want that.
Hold on.
An easement's to move through, not to sit here and park here all day long.
Hold on.
And I don't need to hold on. You can't sit for extended periods of time here. It's not a parking spot. You've been here long enough. You've been here long enough, you need to move.
Hold on. Oh, I can't get it.
Move your car. Move your car. Move your car. Move your car, please. Oh, now you're gonna both get out. Why don't you just move your car?
If you need to go, I'll do it.
Here, you watch her. Well, you watch her. Let me work on this.
Let me try one more time.
16
I know. Hold on. There's something I'm not doing right. I did it
and all the way
before.
around to 36.
Yeah, but wait a minute. That's that.
Uh-huh.
All right, I'm gonna just go to a little bit farther in the video.
I wonder if it almost looked like somebody might. I don't remember that mark on there.
This one, why don't you
See
move
this mark?
the car back
See
by
this mark
Western?
right there?
Yeah, we'll move the car back.
Good. Well, I got a bolt cutter. I can cut it.
Yeah. Yeah, because it's not opening.
Damn it. Here, I'll move. Here,
Move the car. Here, I'll give you the phone.
So that is sort of some of what my clients have been dealing with. And as you can see, and I think the court can imagine that it can be very difficult and stressful when someone's screaming at you and they're trying to unlock the lock. My clients have provided that they've since taken off the lock and no longer have a lock. So they
Ms.
just,
Tideman, can you take the screen share down, please? Because
I'm sorry, I'm going to show another video. So I can if
Gotcha.
you'd like to, but the issue that they are having is simply that even just to stop to open the gate has created a bunch of problems. Let me see. The defendants in support, in discovery, have provided videos from their own security cameras showing what it, quite frankly, typically looks like when my clients would drive in and out. And this is a video showing that. One of the things you can see in this video is that the way the defendants are parking right here, actually, this is the entire swing gate, which would stop here, that is protected by the preliminary injunction. And when you look here, this is the line for that. And we still have some additional things and parking that are happening that are problematic. Turns out there's a button. But these are some of the things that my clients have been dealing with as it relates to their access across this easement. So we have, in the previous photos, we have both the vehicle that is being parked where it interferes with the swing gate that is supposed to be meant open in that lane of travel. We have the trailer and rocks that are being placed in the easement location that is protected by the preliminary injunction. And then we have pretty significant harassment that has been ongoing since the time that this order has been entered. And my clients at this point are just very frustrated with what has been going on and very much trying to figure out a resolution that doesn't involve them being screamed and yelled at and harassed every single time that they are to want to go to their property. Sorry, let me get one more thing. I do have one more video to show, but it's not loading on my computer right now. So if I could just have a minute, but maybe defense can make an argument depending on how the court wants to handle that. I just need about a second to figure it out. Okay, so I have one more video, and this video deals with just sort of kind of the ongoing harassment that my clients are experiencing, as well as the trespass issues that are occurring, which is prohibited by the court order. One of the things that my client provided in their declaration is that on one of the issues they've had with the gate, and part of the reason they put a lock on it is because when they would come back to their property, their gate would be wide open. So they would close it when they would leave, and they would come back and it would be wide open. The defendants do have the ability, because there's a shared well that is on my client's property. But what is happening is that the reason that man gate that was put into there, and the man gate is the one that is where the trailer is being parked, was to allow the defendant's access to the well if needed, if they needed to come onto my client's property, and so that gate across the lane of travel could be shut and they could put a lock there if they so desired, if there was problems, but that would still allow them. So my clients in their declarations provided that on September 28th that the defendants walk around the fence line and start yelling, and that there have been several times during the fall specifically where they would come to their property and the gate would be wide open despite them having shut it. The Banacs on at least one occasion admitted that they did open it and stated that they have every right to go onto my client's property because of the well easement. Well, that may have an easement. It is for the purposes of checking and maintaining the well. It is not an open license to walk around my client's property. And so I'm going to play one more video for the court just regarding some of these ongoing issues with this well.
Out the well.
You can look at the well.
People
Huh?
parking here.
I want you guys to leave that closed.
I have access
You
to
don't
my
want people
well.
parking here and get down.
You guys,
How am I talking to the well?
you leave it closed.
How-
We close it. Go through that gate over there. Move your flower pot.
What gate?
There's a gate right over there.
Two gates.
So you can walk through there. We can drive through here.
A 14-foot gate and a
Everybody
7.
Everybody else drives far away from the other people.
All right.
That they can.
Anyway,
You
any,
want to drive right through the fucking center of my. driveway.
anyway, you've been told. Okay?
You've been told I can walk through there anytime.
You've been-
Nothing.
You've been told to,
Give your court.
you've been told when the gates close and locked.
Dude.
And if
Nothing.
if you knew anybody that
All the
destroyed,
pictures are from a fucking year and a half.
if you know anyone that broke that lock or took that lock, let me know and we'll go after them too.
Good. I hope you do.
Yeah.
I'm on your side.
Okay, good.
You can't have a 7-foot gate and a 14-foot gate when you
Well,
only have a 15-foot easement.
This isn't,
Driveway.
this is just a, okay, well, anyway, you've
What is
been,
it?
anyway,
No, 4 different places for easement.
anyway,
There was 20 people.
Anyway,
been-
I have access to
Yeah.
the right now.
you've been told to
I'm
leave,
go to my.
you've been told to leave the gate.
I didn't hear what he said.
Just leave the gate closed when we close it.
Well, I
Here's
have
what he's
access. I'm going.
You can walk through the man gate.
You can walk where the fuck you want.
Well, anyway, when we close it, you leave it closed.
Yeah, we'll see.
That's the order, my friend.
Oh, order from who? King Sam?
No,
Like you're not a king.
that's the order, my friend.
Yeah. fight with you over the well, the well,
There's nothing,
fishing ground,
There's
fight
not-
with you over the, everything,
there's nothing to fight over.
everything.
There's
You're
nothing-
wrong on everything.
There's nothing to be,
You're wrong on everything. Lie and say that's private property down there.
it is.
Oh, the county sheriff said it's not.
It is.
Oh, you say it is.
I say it is.
Because you're a freak.
Because you show up in anybody else's
You're
backyard.
a freak.
You show up in everybody else's
No, you're-
backyard unannounced and unwanted. Believe me, you're gonna get the same response. Stay out of the backyard.
Freak.
I'm a freak.
Yeah, we got a title that says everything. Got a title there. Cowlitz County told you that that's private property.
It is.
It belongs to the state.
Everything belongs to the state,
That's
basically.
state property down there.
All this belongs
And
to
I
the
have to
state.
take to walk on it.
Listen, when you wanna do something,
Fish on it. But you
hey,
can
just
are just
hey.
the worst human being I've ever met
Okay,
in my life.
But you don't own anything. None of us do. We're glorified renters. Oh, don't spit on me, friend. That's not very nice.
I hate you. I hate you.
Just leave us alone. That's all we've ever asked. Do you have anything else you want to add, ma'am?
Dad,
Yeah. Do you have anything else you'd like to say?
I can walk through that gate anytime I want.
I want you to leave the gate closed if it's closed.
I can walk through that gate anytime I want.
Made
I
it-
have an easement to my well that is back here.
I made a man gate over there so you could walk through and you park
So you
things in
wait.
front of it.
So you built a 7-foot gate and then a 14-foot gate, but your
And then-
easement's only 15 feet. How do you figure that?
Oh, well, that's a tough one.
It is a tough one.
You only need 15 feet to drive through. That's fine.
Well, you can't just steal all my property.
We don't want your property. We want you to leave us alone.
Leave me alone and don't quit stopping on my property.
Okay, well,
The
just,
easement's to move
Listen.
through. It is to move through. It's not to stop, stand there. It's not to have your friends flip me off.
back up, will you?
You back up.
Yeah, I am backing
Don't
up.
stick that thing in my face.
I am backing up.
Don't stick that thing in my face.
You can leave now.
I'll leave when I want.
Yeah, we'll leave now.
When I want.
Okay,
Don't stick that thing in my face again.
okay. Just leave us alone. I will.
And don't stop in my yard again.
You,
Okay?
you stay over there. We'll stay over here. But leave that gate alone.
Don't park. Friends don't park it.
Oh.
So we're just here attempting to gain compliance with the preliminary injunction that is in place. You can see in that video that although there may be a easement across my client's property for ingress and egress, standing on my client's property saying she'll leave when she wants, videoing him, getting in his face, yelling at them, that is not part of a well easement. She is very clearly trespassing at that point. She is violating the order. You cannot just go on someone's property because you have an easement at some point and decide to scream and yell and video them and tell them you're going to leave when you want. It's not reasonable. It's not rational. There was no reason to go look at the well at that point. They certainly, I think it is a far-fetched argument that there is some sort of valid purpose that they were doing in that point. And truly, my clients are just trying to get the order enforced. I think we're probably in the grounds that at this point it's an anti-harassment order situation, but I am hesitant when people are neighbors it creates a lot of problems. So what we are trying to do is we are trying to get the defendants to understand what the bounds of the order is, what their requirements are, and the fact that you cannot just ignore the court order and do what you want because you don't like it. And that is really where they are at. They don't like the fact that the court ordered this. And so they just have chosen to try to not comply. I think they're trying to maliciously maybe comply with it, but it does not seem that this is any sort of compliance with the court order. And what we're hoping to achieve out of this hearing, quite frankly, is that the defendants understand that court orders are court orders that have to be followed. And you can't decide to follow whatever you want and enforce whatever rights you want, but violate every other order and every other right that my clients have. My clients at this point truly are fearful to go to their property because of these ongoing things. While I have showed the court a couple videos today, these are not the extent to the interactions between these parties. And these are things that are happening so frequently that my clients at this point do not feel good about going to that property because of their interactions. And that just shouldn't be the case. So when we look at, are they interfering with the use and enjoyment of my client's rights over that easement and access to their property? The answer is yes. Are they placing a trailer in rocks where the easement location is and they are prohibited from doing so? Yes. And are they trespassing on my client's property by opening the gate, coming onto the property to scream and yell and video? Yes. So we're asking that the court hold them in contempt today. We would like to, again, handle it this way. Our next step likely is an anti-harassment order. But given that these parties live next to each other, we would like to attempt to enforce it this way. Secondarily, we are asking for an award of attorney's fees. And given sort of the length that this has been kicked out, I would like to have an opportunity to do a fee affidavit for that, because it's not just a simple like $750 because of the nature of these proceedings. Thank you.
Let me just ask, is the trailer in front of the man gate still to this day, or did that get moved at some point?
That was there in the videos, which happened in both October and spring of 2025, so well after the order. Miss Annette, I don't know if you can speak to if it is still currently there. I do not know the answer as of today.
Still there.
It is still there. Okay.
Correct.
Okay. Thank you. All right, Mr. Weiss, I'll turn it over to you.
Okay, I appreciate it. There's a lot to unpack here, but it essentially comes down to this is me speaking. This is a petty, dumb dispute between neighbors. We've been working to try and resolve it, and by we, I mean my clients and I.
Mm-hmm.
Frankly, I think a lot of what Ms. Tideman said is disingenuous, that they've been trying to resolve it. Because since I've gotten involved in this thing about 2 months ago, have not gotten a call back but once for her, because I wanted to avoid this hearing, and my clients wanted to avoid this hearing. This hearing is just a waste of time. This hearing itself is harassment. This is litigation harassment of my clients. I think plaintiffs are trying to outspend my clients in the courtroom, and there's no point to any of this. Turning to the subject at hand, what order have my clients violated that's worthy of a motion for contempt? Ms. Tideman paraphrased some order, but I want to know what the language is. They have to prove that my clients violated a direct order from the court that's written, and that's simply not happened. I mean, frankly, they've completely failed to meet their burden of proof here. The videos show what the videos show. I think it shows a bit of reciprocal pettiness on both parts. I'm not trying to throw my clients under the bus. They're frustrated. I think the plaintiffs are frustrated. But my point is that none of it amounts to a legal contempt remedy. I don't think that the court has enough information to make that finding. Ms. Tideman's motion and then her argument here today makes reference to a July 20, 2023 order. Well, Your Honor, that order was superseded and is no longer in effect by virtue of an August 30th, 2023 order. So if their motion for contempt is based on the July 2023 order, you have to deny it because that order is not valid. It was superseded by the August 30th, 2023 order. That said, the language of the August 30th, 2023 order, if you're going to take that one under consideration, is very similar. But the language from that order is, and I will not paraphrase, I will quote directly because I think that's what's required for a contempt order. It reads, and I'm reading directly from the August 30, 2023 order. It says, therefore, the court orders 1, plaintiff's motion is granted. 2, defendants, its officers, agents, servants, employees, and attorneys, and all other persons in active concert and participation with defendants who received actual notice of this order shall be restrained from trespassing on plaintiff's property and restrained from blocking the easement. On a temporary basis, defendants are restrained from blocking or interfering with the existing swing gate adjacent to the man gate and access across the entire lane of travel through the entire width of that one gate. Period. End quote. So insofar as the court's going to consider an order that my clients may arguably have violated, you have to consider that one, and that's not what plaintiffs are moving on. But so let's look at the language of that. They're temporarily restrained from blocking and interfering with the existing swing gate adjacent to the man gate. The order by its language excludes blocking the man gate because it specifies the swing gate adjacent to the man gate. So the fact that there's a trailer there sometimes and not other times is completely irrelevant because it's not in violation of this order. So the trailer is a complete red herring, and frankly, today is the first time I've heard Ms. Tiedemann even talk about it, and that my clients have known about it. Regardless, go ahead, it's there. Let's assume it's there. Let's assume it's remained there the whole time. It's not in violation of this order. So it's not a basis for contempt. Period. I mean, the language says what it says. Your Honor, I want to provide some context here now, and I would like to screen share as well, too.
Okay, you should be able to do so.
Okay. Well, are you able to see, Your Honor,
Yep.
Ms. Tiedemann?
Mhm.
Okay. So I'm showing a very similar picture to what Ms. Tiedemann showed, and I have, of course, done the markings on here. So this is the view down the driveway, similar to what Ms. Tiedemann showed. On the right is my client's garage, and the green Jeep Cherokee is theirs. So this is the view looking down towards the Annetts property across the Bennex property. Now, there is a clear path to the entire 35-foot width here. The easement, Your Honor, and this is critical, it's 15 foot wide, as close to the Kalama River Road as possible, which is to the left in this picture, or the north, if you saw a compass on there. So this problem, this whole dispute between the Annetts and the Bennex is of the Annetts making. And here's why. Because in 2018, the Annetts built this fence that is pictured in this photo. And they built it with a 7-foot wide man gate to the north, or as close to Kalama River Road as possible. Now, a vehicle could not drive through there because they put a 7-foot wide man gate. So I'm zooming in a little here. And it's right on the property line. I don't think there's a dispute over that. It's essentially, it runs north-south right on the property line, dividing the Annetts and Bennett's property. But the Annetts built a fence with locks on the boundary, and they created this problem that didn't exist before that.
So, Your Honor, I just want to make a preliminary objection, and I don't mean to interrupt, but the argument counsel's making has been adjudicated by the court in subsequent hearings. So while that was the argument at the beginning of the case, the court has found in favor of my clients as to the easement location in both a summary judgment order and a revision order.
Yeah, and I will bring that up in my ultimate ruling here, but Judge Scudder did issue the order on revision, which did clarify that easement was not moved, that it does remain in that place regardless of the fence. So, I mean, I guess let me ask you this, Mr. Weiss, and
Sure thing. And
then jump back in. But I mean, it's very clear from Judge Scudder's ruling on order on revision, that right in front of that 7-foot wide man gate, that is part of the easement.
Right.
So why do your clients still have a trailer there?
Well, they don't all the time, but it is their property. They're
the ones yelling and screaming. And I'm going to be honest. I think there's no adults in the room when these 4 folks are conversing with each other. But if they're the ones yelling, don't park here, you can't park here through the 14-foot gate, and yet they're parking a trailer pretty much permanently in front of 7-foot gate, how does that not run afoul of the August 29th, 2023 preliminary injunction order, which says you can't block the easement? The BenX cannot block the easement.
Well, it's not there now. I understand it's parked there at times, and other times it's not. However, what's important, it's a red herring because the trailer park there doesn't block their ingress and egress access. It simply doesn't.
It does, but the order doesn't say not to block ingress egress. It says BenX are temporarily restrained from blocking the easement. And the Judge Scudder has ruled that in front of that 7-foot wide man gate, that is the easement.
Well, see, now I guess we're into an evidentiary hearing because my clients will tell you that it's parked there at times and not others. And I'm paraphrasing. I frankly don't know what they would say, but I've
right, but they're yelling at the plaintiffs when they stop their car to unlock a gate. You can't park here. You can't park here. You can't park here. So
Right.
they can't, right? They can't have it both ways. They can't say you can't park here for, let's say, even up to 30 minutes to unlock a gate, but we can park our trailer here for days on end, but we move it sometimes, so it's okay. I mean, it just doesn't work that way.
No, I 100% agree with you, Honor. In fact, I had written down when Miss Tideman was arguing what's good for the goose is good for the gander.
Yeah.
The Annets want them not to park their trailer on their own property, and the BenX want the Annets not to park their car to get out and take time unlocking a gate that they put in, and frankly refuse to put just an automatic gate opener that would solve this whole stinking thing. But yeah, so I agree with you in some regards. There's both want the benefit of the easements without the downside.
But go ahead. I
appreciate it. And I'd contemplate these things. So I'm going to keep clicking through some of my photos here. So I just wanted to show the court clearly that there's a wide gravel path here, or driveway rather, but the Annets only get to use the north 15 feet of it. And that's consistent with the order entered by Judge Scudder. It's just that the Annets had built their fence 7 feet into that 15-foot easement, which only leaves 8 more feet, because 7 plus 8 is 15, and yet they have a 14-foot gate here. I mean, the whole length of the 7-foot man gate and the 14-foot car gate is 21 feet. So it exceeds the easement by 6 feet.
I don't think that they are violating the path to the vehicle gate. I don't think your clients have blocked the path to the vehicle gate.
Okay.
I think the question here, and I'm also going to say, there's a lot of allegations of harassment back and forth. And frankly, I see harassing behavior on both sides. If we were here on an anti-harassment order, we'd be going through different factors for sure. But harassing behavior was not enumerated in the August 29th, 2023 preliminary injunction order. So I can't make a finding of contempt based on that, even if I think the behavior is childish. So really what I'm looking at is, I don't think they have violated the preliminary injunction with regard to the 14-foot vehicle gate. I don't think they have violated the preliminary injunction with regard to harassment, because that was not discussed in order. Two things stand out to me to kind of hone in on for your response, which is the trailer, which has been there since August 29th, 2023 in front of the 7-foot man gate. That does appear, at least preliminarily, to be a violation of the preliminary injunction. And when Mrs. Bennett goes on the property claiming, hey, I can be on your property and access my well, she's not looking at the well. She's camera up in someone's face, antagonizing the landowners that she's on, saying, nope, I can do this because I can access this well. Well, then go to the well and do something. But she doesn't. She just continues saying, I can be there, I can do this because I have an access to the well. And she doesn't even go to the well and do anything with the well. So that is prima facie trespass onto their property. So I guess those are the two things that I think are violative of the preliminary injunction order from 2023.
Okay, understood. Well, so let me click through this real quickly, and I understand, because I was prepared to address some, but not all of those things that you brought up. So let me go just to the next photo here. Let me zoom in. I really put this together to illustrate the distances, and it seems to me that the court's clear on that right now.
Yeah.
7 plus 14 plus 14 is 35 foot wide. Again, the annex have a right to use the north, or in this photo, the right 15 feet of that. I want to say that this photo is a bit deceptive. This was, I think, submitted in discovery at some point by the annex, because from the angle it's taking, it seems to suggest that a vehicle can't drive to the right in the area where the man gate is, and it suggests that the green Jeep that's owned by my clients is somehow blocking the driveway, but it's really just deceptive because of the angle of the photo.
I noticed that too on another picture. I think it's more likely the angle. So, I mean, I'm just telling you, I don't think that I can find that they have blocked the 14-foot swing gate.
Okay. Yeah, and again, this is another video, or sorry, a photograph with the gate open. You can see it swings in. Notably, Judge Scudder's order says that it only swings out. Frankly, it's factually incorrect. This photo unequivocally shows that the gate swings both ways, and in fact blocks my client's driveway if there aren't planters there and it opens inward. So the easement in this area is this green line where I wrote approximate 15-foot easement. I haven't measured that. I'm admittedly eyeballing it, but I'm just illustrating. Sorry, the zoom features make it difficult for me to. Okay, there we go. The zoom drop down covers my ability to click to the next. So another photo here. Again, this is just me showing that if the man gate wasn't installed here, then this vehicle gate could have been installed 7 feet to the north, and we don't have a problem. At that point, the annex are completely within the 15-foot easement area.
And I agree with you.
Okay.
But for the times that your clients have that trailer parked there, which takes up that 7-foot man gate, I think that's the rub for me.
Okay.
But your perspective is true that 7 plus blank is that 15-foot easement, and it starts right there in front of that man gate. So I agree with you. If the gates were rearranged differently, maybe we're not here, but they can't park in front of the man gate because that is the easement.
Okay, and I'll say, frankly, that was unclear to me, because if the purpose of the easement is for ingress and egress and no vehicle can drive through the man gate, it's immaterial whether there's a trailer there. It's not blocking vehicle access. It's not even blocking pedestrian
But
access.
ingress egress isn't just vehicle. It could be a bike. It could be walking. It could be anything.
But they have the remaining 8 feet to go around and through, which is sufficient for a vehicle to fit. That's my point.
Well, then we run into issues with how far out that car truly is. So I guess here's my point. My point is, we all agree there's a 15-foot easement from that point. Judge Scudder agrees with that. I think you agree with that. I think Ms. Tideman agrees with that. So the trailer has to be moved. I mean, that is.
Yeah, and I think it is, Your Honor.
Okay.
And I could have my clients provide testimony about that. I frankly wasn't prepared for it today because I didn't exactly know what the issues that were going to be brought up by Ms. Tideman were, and I didn't know it was going to be germane to Your Honor. But here I want to show, this is another photo. This is taken from essentially a still shot from the security camera. Here, let me zoom in a little bit. But you can see that the trailer's there, present, parked, blocking the man gate. Insofar as it matters at all. The Jeep is parked, but there's still enough room for the Prius, the annex vehicle, to enter and exit. And the vehicle, the gate, significantly, that it's driving through is only partially open. I mean, it's a relatively small vehicle. It can fit through the gate. So I just wanted to show this to the court to show, hey, nothing's actually blocking their ingress and egress, regardless of the trailer being parked there, of the Jeep being parked there. They still can get in and out of their property. So I'm going to stop share for a moment. I want to show some videos too.
Okay.
Mine are shorter. I think the snips are each less than 20 or 30 seconds, frankly. This is, yeah, the videos are a little trickier to prepare for because I have to open them. Okay, so here Miss Annette gets out and she flips off my clients, gives them the bird, and that's it.
Yep.
This was in November of 2023. And I don't want to misrepresent anything to the court. I did my best to discern the dates of these because I think the dates are relevant based upon the digital properties in the file. But I wouldn't swear under oath that the dates are accurate. But so the next one is Miss Annette filming my client for no apparent reason. And this is from November of 24. And so my client's pictured next to the trailer, and Miss Annette's on the right of the screen, filming him kind of inexplicably. Which nobody likes to be filmed on their own private property.
I guess just for the purpose of today, I don't know how it's relevant as to the contempt.
Well, this is a two-way street. I think Judge Carmi, you see that this harassing filming behavior. But granted, I understand Ms. Tideman saying, but so.
Yeah, and I guess a lot of this, especially the harassment, it's not going to play into my ruling on the contempt. But again, I think both parties have showed very childish behavior that probably would form the basis for an anti-harassment order, frankly.
May I continue showing videos?
Yep.
This is the live video from which I gave the screenshot, and this is from I think May of 25. So as of May of 25, the trailer's present, but you can see Mr. Annett can drive through. He can close the gate behind him, and he does, and it's not obstructing. The next video is from August of 25. It's taking a second to load. There, the trailer's gone, as are the rocks. And this is after the judge's recent ruling. So the clients had moved the trailer and they had moved the rocks following the summary judgment. And I have the date on this one correct. It is August 17th of 25. So again, Your Honor, to show you, the trailer's gone, the planters are gone, and the any obstructions are gone as of the date of this video. The next one, this is September 1st of 2025. I think that date's correct. And I don't think it can be seen, but the trailer is not present on the other side. This is a worker that had come to the Annette's house that couldn't get in, and so he parked his big old pickup truck in front of my client's car, blocking him. Mr. Bennett comes out, talks to the worker politely. Because the worker can't get in. Oh, I see. Notably, Your Honor, in this video, both swing gates can be seen moving. So, and there's access through there. So there's no obstruction to the gate going both ways. And so that's September 1st of 2025. The next one's September 28, 2025. So we're talking less than 2 months ago. And the trailer's gone, the obstructions are removed, and both swing gates are open. So now the Annets have the full 35-foot width to drive through, even though the easement's only 15 feet. This is from this month, or no, sorry, this is from October 6th of this year. And this is actually a movie image. You can see by the B flowing, but this is just to show that the Annets will park a vehicle in the easement and leave it and go into the house. Here's the other thing. You can walk around this man gate. That was Miss Annet, I think. There's any walking around the man gate. Well, what's the, I'm rewinding it. So what's the significance of that? Well, this notion that the Annets built this man gate to provide my clients access is completely false, because you can just walk around these gates at any time. It's a misrepresentation. Even the Annets don't walk through the man gate. They walk around it when they want to park their vehicle and drive off. So here, I'll stop the screen share. Actually, I do have still screen sharing. I'm showing a photo here. This is a lock that's on the man gate. I'm only showing this because it undermines the argument that the plaintiffs are making that the man gate was installed for the benefit of my clients. They've locked it with a combination padlock, so my clients can't even get through the man gate. They either have to go through the vehicle gate if they can unlock it, or simply walk around it like Miss Annet was just seen doing in the prior photo. This photo I'm sharing is, again, just to simply show that the gate in its current configuration can swing in and does swing in and block my client's driveway and access to their garage and access to the side of their garage. So I'm going to stop the screen share. I'm going to go back to with what I started with. This whole problem could have been avoided if the gate was just built a little differently and constructed differently. My clients have been trying to resolve this, and frankly, I've been trying to get Ms. Tideman to call me back to just simply put an electronic opener on it or move the whole gate 7 feet to the north. I mean, they would have spent less money doing that than attorney's fees, certainly. So this whole concept kind of blows my mind, in my client's mind, but there's nothing my clients as defendants can do to dismiss this case. They're just being harassed by litigation. I mean, if the plaintiffs won't settle for anything because there's nothing they clearly want other than harassment here, what can my clients do? My clients clearly are perturbed that they're A, being sued, B, that these people, the Annets, keep just parking in their driveway, and see that they have an obvious solution that they're not undertaking. I mean, there is an obvious solution here. So I want to return to the point of this hearing. What evidence is there of contempt, and what, insofar as there's any contempt here, what's been the harm and what's the appropriate remedy? Particularly, I think the court has to weigh in that we've been trying to resolve this, and it's a problem that only the Annets can fix. That's the problem. My clients
Well,
can't.
Your Honor,
move
my
their
objection
gate.
here is that he appears to be making some sort of settlement argument. And if we're going to talk settlement discussions and negotiations and have that be part of this hearing, I am happy to do that. But I don't think that is appropriate or acceptable in this context. And I mean, I'm happy to make some arguments, but it seems like we are talking settlement negotiations rather than.
And I'll overrule. I don't think it's settlement negotiations as much as kind of common sense, how we get these parties to be better neighbors to each other. So I'll allow it, but I mean, I think we can probably wrap up this hearing. I do have a hard stop at 2:30, so.
Sure. And I apologize. I didn't even mean to go as long as I did. So, Your Honor, to address the issues with the trailer parked in the easement, I'm going to go back to what I started this with, which is the original order, the preliminary injunction does not preclude the obstruction of the man gate. It just says they should not block the 14-foot gate, and they haven't. And so I would encourage Your Honor to go back and take a look at the.
No, I have it up in front of me, but it says, and they should be restrained from blocking the easement. Judge Scudder has ruled that the easement includes that space in front of the 7-foot.
Okay, so
we can agree to disagree on that point, but I do think that the man gate, the 7-foot man gate blocking that is part of that temporary order.
Sure.
But again, this isn't something I'm throwing people in jail for. Like,
right.
I think that there's, so go ahead.
Sorry, let me get clarification. So, Your Honor, are you looking at Judge Scudder's order from August of this year, or are you looking at the August 30, 2023 order?
It's not August 30, it's August 29th, 2023 order for preliminary injunction. That says, shall be restrained from trespassing on plaintiff's property and restrained from blocking the easement. On a temporary basis, defendants are restrained from blocking or interfering with the existing swing gate adjacent to the man gate and access across the entire lane of travel through the entire width of that one gate. So 2 things are happening. They can't block or interfere with the existing swing gate. I don't think that has happened, but they're also restrained from blocking the easement. And so when I say Judge Scudder's ruling, I'm talking about his subsequent 2025 order on revision that describes what the easement is, and we all understand it to be that 15-foot area that does include 7 feet, does include the width of the man gate.
Sure. Well, I'll be candid with you. I don't have the August 29th, 2023 order. I have, and so
I can probably clarify why you're confused. So
I would appreciate that.
It is the filing date in Superior Court is August 29th, 2023. Judge Warning signed it and put August 30th on his signature page. I think he just was perhaps wrong about the date. Okay,
yeah, I think.
So I think that's why the confusion, or at least that's what I'm looking at. I might have a conform stamp on the 29th and a signature of the 30th. So that's probably the confusion.
Yeah, yep. I appreciate the clarification.
So we are talking about the same one.
Yes. So, Your Honor, why I wanted to show the videos too, and why I was specific about the dates too, is I believe that Judge Scudder's ruling in early August of this year was clear to me and my clients, and they have since moved the trailer. And that's why I showed the videos, because it's not there in the videos after the date of that order. So I think that's been resolved insofar as the judge's order from this August was clarifying. In terms of the trespass, my clients do have a well ingress and egress easement. Your Honor saw the video. I think it speaks for itself. I'm not going to add any commentary to it per se, but other than to go back to what I said earlier, which is good for the goose is good for the gander. And I think what we're talking about is the scope of easement use and whether people are overreaching in their scope of an easement. my clients have the right to go onto the annet's property for purposes of well maintenance and so forth. And the annets have the right to use the easement across my client's property for purposes of ingress and egress. At what point are they overstepping the scope of that? At what point are they overstaying it? And my clients believe that the annets are overstepping the scope of it, and that there's an easy solution that only the annets can do that's frankly cheaper than all this litigation. And so it's kind of nonsense. I'm asking that you deny the motion for contempt. I don't think that they've satisfied the burden here. And I think that there's plenty of evidence to show that my clients have accommodated the annets by allowing ingress and egress. They've never blocked a vehicle. In fact, there's no allegations anywhere at any time that my clients have prevented the annets from going into and out of their property. The only thing preventing them from going into and out of their property is the gate they built. Thank you.
Ms. Tideman, briefly.
Yeah, thank you, Honor. It sounds like the court is not wanting any argument on why hollering is interference, so I'm not going to talk about that. But what I will say is that the order from Judge Scudder was clear that essentially that my clients built the gate and the swing gate that was in line with the easement that had always existed. My clients had to file this lawsuit because the NACs started to put planters out blocking almost half of the car gate that they go through. And that is why we had to get a preliminary injunction that was granted by Judge Warning that stated that they needed to not interfere with the easement. And again, the order is clear that they're blocked and restrained from blocking the easement, which is the entire easement. There was never a fight about the fact that it started nearest Clamor River Road. And so the additional language of the swing gate was because that was the dispute between the parties of if that swing gate was encompassed within the easement. Everybody agreed that the part by the man gate is encompassed within the easement, but you can't park and you can't block it. If the court wants information on the trailer still being there, my client did provide that it was still there. I will also provide that the video where it was alleged she walked around the man gate, that wasn't my client. That's not their car. That wasn't her. So we have a video of somebody doing that, not my client. Parking there, not my client. None of that video was my client. So I'm not sure who that was, but it was not my client. So this idea that we have a video of my clients parking and then walking in and then coming out, it's not her. The issue is that obviously these neighbors have had some contention. Our hope was that once these orders came down that it would help, but the contention has continued. The placement of the trailer has continued and it's been not coming onto the property. I think it's very clear a violation of the preliminary injunction order. We're just trying to gain some compliance so that we can hopefully get a settlement resolution, but we can't do that if everybody is disagreeing and not following even the current orders that we have. It really does create a barrier to settlement when people are not abiding by the current orders even.
Thank you. Thank you all. I know this has been some time in the making, just with changes of counsel, court schedules, frankly. So I appreciate everyone's patience, your time today, presentations. I mean, I don't want to be harsh here, but I tend to agree with, I think, the general sentiment everyone may be feeling as they hear and see this case, which is, again, come on, I need 4 adults in the room at all times. So that includes plaintiffs and defendants. Everyone's out there filming each other back and forth, saying things they probably don't mean to say in the heat of the moment. Nobody wants to live in an environment with neighbors like both the plaintiffs and defendants are experiencing right now. So I strongly encourage you all to work together to figure this out and create some peace in your lives. Because gosh, having this kind of stress with your neighbors is not healthy. Not healthy for you mentally, physically, all of the above. So that's kind of my non-judicial chat. That's my mom talk, I guess I could say. But going to what's actually in front of me, I'm kind of the preliminary injunction does not talk about harassing language or behavior. I think that that's clearly occurred, maybe both ways. That's not in front of me today, though. Does that harassing behavior block access to the easement? I think I understand that argument. A little hard pressed to find contempt for that, though, based on the language of the August 2023 order.
And I just want to clarify, we weren't claiming it blocked, but that it interfered with the use and enjoyment of the site.
Yeah, I mean, and I see that. Again, in my mom voice, I'll say, you all hear what's being said, and you probably all know that's true. I'm not going to base a contempt finding on that. I think that there has been a violation of the preliminary injunction by way of the trailer parked in front of the man gate. My remedy for that is I'm going to set a compliance deadline where I want either the parties to agree that by November 21st, so next Friday, that trailer is not there and will not be back there unless and until further order of this court that allows it. My hope is that happens in time before Thanksgiving, if anyone plans to have folks over or utilize their property for the holidays, that sort of thing. I also do believe that the preliminary injunction order has been violated by trespass by Mrs. Benak on the property of the Annettes. You cannot go on the property to engage in video recording of the other person just because you have an easement to the well. Easement to the well is to deal with maintenance, checks, construction, repair of the well. That's all that easement allows. What I see on the video is, hey, let me in the gate. I'm going to stand on your property and video record you because I have an easement to the well. That is a violation of the order. Again, though, I think that this has probably gone both ways. I think probably sometimes the Annettes purposely sit a little too long in front of that gate, frankly, just to piss off the other party. So I'm not sanctioning anyone. I am making a finding of contempt, but essentially I'm going to call it my first strike. This is the warning. And if this comes back to me on a motion for contempt for that same trespass behavior, then there will be greater sanctions. I'll briefly address attorney fees. I mean, I understand in a motion for contempt, typically attorney fees are awarded. I will authorize what I'm going to call a sanction for the contempt. It's going to be $1,000 towards attorney fees. I do think some of this motion kind of went into the realm of an anti-harassment order, so I am going to curtail the amount that has to be paid. But I will indicate a $1,000 attorney fee sanction that'll be paid by the Benaks to Ms. Tideman's office. With all of that said, I think the remaining issue is for purposes of the record, if the parties, I guess, probably should submit USBs of the video to the court at some date before, an appeal period or a reconsideration period. So I'll leave that to the parties to get filed. Do you want to set a presentation date for this order, or do you think you all can agree?
I don't think we need to, since you're regularly on the civil docket, that if we needed to, it'd be pretty easy to set a presentation. And I think what I can do is we can prepare the order, and then when the order is signed at that same time, we can bring all the video evidence to the court and submit it as well. So it is entered it is submitted at the same time as that order, so it wouldn't get any sort of reconsideration or appeal period that may run.
Okay.
I'm in agreement with that.
Okay.
And Mr. Wise, if you want to send me copies of the video, I can, if we are going to file the order, I can just take them over at the same time or handle it, or we can figure it out.
Sure. Yeah, we can communicate about that.
Sounds good.
Okay. All right. Thank you all. Again, I wish all the parties the best of luck. Make life easy on yourselves and figure out how to be better neighbors to each other, because life's stressful enough. So, okay, take care, everyone.
Thank you, Honor.
Okay,
I will
thank you
go
for your
ahead-
time.
Yep, I'll go ahead and end docket.
If you're involved in a dispute with another party such as this and you just can't seem to work it out, don't resort to taking the law into your own hands. You take it to court.
All right, thank you very much. Officer Burrell's waiting for you, and that will bring this case to a conclusion.